Okay. Well, this is the final lecture of the 5 lectures that I do, or actually 6, counting the open house. Week 2, 4, 6, 8, and then this is 10. Next week is the final week of the class. And so we're going to talk about a few things, reminding you that week 11, you have a final exam, which consists of 40 questions, true and false. But we'll talk about that in just a minute. So let's go right into and see what we got here. Again, I presented this information to you. Still an opportunity to apply for a position as a tutor, and if so, reach out to Bethany Marston, or better yet, this link down here, and it gives you all the information there. Okay, and so all the information is the same on the home page. I've had a few people ask me questions, and I know that they didn't look at their home page, because their home page looks like the one that I have here, reminding people about research, but more importantly, the APA format, citations in the body, and references at the end. The only time this quarter that you didn't have to do references at the end was in your interview that we completed in week number 8. But other than that, your written assignment, citations in the body, and references at the end are required. So you want to make sure that you get those. Okay, let me go back and see something here. Let's go back to I want to check something. Okay, there it is. All right, so let's share that screen again. Not that one. Okay, that one right there. Okay, so now there it is right there, your home page, and it shows all the information there, and then about the tutoring that I was just talking about a few minutes ago. So now let's get right into the announcement for the week. Juvenile offenders, and section 13 of the text, juvenile justice system, historical perspective, and then the role of the juvenile probation officer, which was the discussion post that was due on yesterday at 11:59 p.m. Central Standard Time, and reply post due this Saturday at 11:59 p.m. Central Standard Time. And then your written assignment, waiver process, and the quiz. And then finally, my motto, adversity is a springboard to success, which I've shared with you this whole quarter, explained it to you from day 1. Okay, so now let's get into this. Let's take a look at our calendar. Which again reminds you of the assignments that are due. We are right here in this week, and it tells you what your reading assignments are, and it tells you everything that's due, including your reply posts. And then your quiz is due on Saturday, on the 11th, which is Sunday, and your written assignment that we just got through talking about your state's waiver process. Now, I want to take you into the following week, just to show you your initial post is due as normal for the week 11. However, everything else is due on that Friday the 16th. And that includes your reply post, which is normally due on Saturday. It must be in by 11:59 p.m. Central Standard Time, or else it will not count. Your written assignment for that week 11 must be in, and you must have taken the final exam, because here is the final note. The quarter ends at 11:59 p.m. Central Standard Time. 12 o'clock, can't take it. If it's 12:01, I can't. I do give people breaks, but I can't do it here because the quarter actually ends, and I'm required to abide by that. And so I encourage everybody to make sure that they be aware of that, be cognizant and conscious of it, and abide by it as well. Okay. So now let's take a look at Module 11. Look at the assignments real quick. This is a 2-page paper. Most of you have been doing 2 pages. Sometimes people do a page and a half, and I'll let you know that. Some people do just 1 page, and you're going to explain your state's waiver process involving juveniles. And you're going to make sure that you complete these assignments, and you have your citations and references as APA format is required, as I've already shared that with you. And you want to make sure that you do that. Again, there is a rubric that I've given to you for all those assignments. And then finally, your discussion, and then your quiz that's due, final quiz. And that's what's due then, okay? So before we get into going back to discuss it, I want to take you just for a moment to the assignments for next week, as I just showed you a few minutes ago. Technology in your local correctional systems, 1 or 2 page. 1 or 2 page paper. This is one of the times. There's one other time I think that you have 1 page paper, but 1 or 2 pages. Now make sure that you run them through Grammarly, because you don't want to get hit with a Grammarly hit on the percentage. Citations and references, cover sheet as well. Your discussion post, initial post, again, due that Tuesday, and then will be the reply post that particular Friday, the last day of class. And then your final exam, 40 multiple choice and true-false questions. That is set for 40 minutes. You'll have just one opportunity to complete this quiz. Make sure that you're ready for it. During the exam, you'll be alerted about when you have 20 minutes left, and then when you have 5 minutes, 1 minute, and then it gives you a countdown. When you start this exam, you agree to abide by the academic misconduct policy set forth in the syllabus. If we discover that you're not, you're going to run into a problem, such as having 2 screens open to have information as well. Of course, so you'll be messing up because you won't have enough time to complete it. This is supposed to be a closed book exam. There's no way for us to know if you have a book open in front of you or what, but trust me, it's going to show up with the exam itself. You need to study hard and go over the material that you've had to cover in this course. And you should have been all along every week keeping an outline information so that you're ready for that final exam. Very, 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 very important. Very important. So that's all I can say about that. I can't give you any more details on that. Since there's no lecture, again, I remind you, it must be completed by a week from Friday. Okay, so now our objectives for this week is to deal with juveniles, and then we're going to talk about some of these sections, and then we're going to answer any questions that you guys may have. So let's start by talking about the juvenile justice system. And, you know, the whole idea of the juvenile justice system is not to punish. It's to rehabilitate and try to salvage our youth. And the concept of parents patriae is the concept that came from England, and it's Latin. And actually, it really means that to be step in and operate as parents would do correct a child. And it's not to penalize them, but to give them a lesson to teach them so that they won't grow into adult criminals. And so we want to make sure that you understand that's what juvenile court is today. With the parents, and in fact, you should be aware that juvenile courts are different from adult courts. You can walk into an adult court, generally it's public, but you cannot walk into a juvenile courtroom because it is not public, it is private, and only the parties that are involved are invited. It says while the juvenile justice system is very similar to the adult system, and the interests are made in the best interest of the child, then the process begins with what we call a petition, not an indictment, not a summons. And juveniles are not arrested, they're taken into custody. Now, they have the same protections when they're taken into custody as individuals have as far as the right to Miranda. They have a right to be Mirandized. But and so how to enter custody? The same way you know when you're arrested. That is, you're not free to go. They are detained and not jailed. Again, notice the intent of the language is to take the individuals and to put them in a holding situation. Jail is that too, but jail is more penal than rehabilitation. Adjudicated is when a individual is found to have committed the act. They're not found guilty in juvenile courts. And then a disposition is given to them, not a sentence. And the terminology is very important because it focuses on the intent of the juvenile justice system. Probation is often ordered for, it says, an indefinite period of time. And juvenile probation officers control and operate that. As in the case of the adults, an investigation is done about the background of that individual, and reports are ordered before disposition. Now, that gets to the point that the disposition comes about the same way in a criminal case, in a criminal case, of course, being found guilty or adjudicated in a juvenile case, or a plea of not guilty, but a plea where you voluntarily allow yourself to be adjudicated. And then a disposition is given. And juvenile offenders are basically put into positions right away based upon their risk and needs, which is the same kind of thing I've advocated for adults. And case plans are developed to determine the programs and what the services are that the juveniles needed. Juvenile probation officers work very, very closely. They work more closely with the family than adults. The key thing is to try to get that individual who's on juvenile probation an opportunity to blend back in with the family very quickly. And that's the way that recidivism is dealt with in terms of the juvenile justice systems. Now, it says further that juveniles can be placed out of the home for reasons such as some have committed offenses where they have to be in group homes or sent away, boot camps, wilderness programs, and sometimes secure detention. And secure detention is oftentimes like jail or prison for them. But the point of the matter is, as soon as they're there, education and all the services that are necessary to try to point toward rehabilitation are offered to the juvenile. And there are many, many programs where the youth is given an opportunity to have a second chance. Now, non-residential programs also occur where the individual remains in the home but also receives education, treatment, and other services in the community as well. The key to remember about this is the goal is to salvage that juvenile. Now, when we get to the point that we are now, as you and I both know, that at this time juveniles are committing many offenses and are being tried as adults because of the type of offenses that are taking place with the presence of gang activity, drug distribution, and things of that nature. They can, in those situations, be waived into adult court. And that's one of the assignments that you have this week, is to look at your jurisdiction. Every jurisdiction is different about the waivers to adult court. But the key is that it has to be a very serious offense that those individuals are involved at. Adult sanctions, including prison, now apply. So the point of the matter is that the protection of the juvenile justice system is is removed because of the seriousness of the offenses that these individuals are committing. And it's still, you still want to try to salvage them, but there are all kinds of problems that take place in those situations. Now, we don't advocate that because you're in prison that you'll be placed in a facility where there are adults, because if you do that to a young individual or juvenile, then it's equivalent to taking a goldfish and putting it in a bowl where there's nothing but piranhas there or sharks. The point of the matter is they'll be eaten alive and they'll be consumed, and any opportunities for salvaging them will be consumed, and they will ultimately end up being destroyed. And as pointed out here, exploited by the adult offenders. As a matter of fact, you should be aware of the fact that many juveniles, as far as drug distribution is concerned, end up getting less time. So they're the ones who, when they get busted with drugs, they're out faster. And if an adult is caught with the drugs. And so the key thing is that this is another form where the adults are manipulating and utilizing the youth that ultimately end up in the juvenile justice system, and they know it. But the key thing is that almost every jurisdiction that I'm aware of, including my own, Illinois, is working very feverishly to try to reach a resolution to dealing with the fact that our crime from juveniles has gone up, and that with the presence of gangs and shootings that take place and things of that nature, we need to begin to operate on a more, how should I say, intense basis, so that what has happened is that there are things that are taking place with youth and juvenile justice systems, such as more house arrests, more electronic monitoring situations with the technology that we have now that we did not have before. The key thing, again, is because of the overcrowdedness of the prisons, most of the jurisdictions, including Illinois, has budget issues. In fact, Illinois doesn't have really an issue for budget because they don't even have a budget. They haven't had a budget for the last 2, going on 3 years here now. So it's a problem. It's a real problem. So even those jurisdictions that do have budgets, there are restraints on the amount of funds that are set aside and provided for addressing the issue. So it just continues on. So the juvenile justice system, in a nutshell, is to make sure that you understand that the key is to try to salvage the juvenile and not to punish them. And again, when juveniles even commit adult offenses, they are tried in adult courts. But the fact of the matter is that they may spend longer periods of time than if they were in juvenile systems. Any questions about the juvenile system before I move on from either of you? Any questions, comments? Okay, John, none? Okay, all right. So now let's take a look at, the history of the juvenile justice system going back to 1966, Kent versus United States, which made it clear that courts must provide the essential due process in transferring juveniles to adult system. In other words, what that meant is that they have a right to respond. You don't just because the offense is serious, but you have to look at the opportunity for the individual to not justify the offense, but to justify the reason why they should not be placed in the adult system. Because again, that's a drastic move on behalf of what these individuals are concerned. So then that's 1966. In 67, in Ray Galt came about, in which it was determined that, and these are major Supreme Court cases, United States Supreme Court cases, that said that hearings could result in the commitment to institutions where 4 basic constitutional rights that are maintained. The right to notification. This goes back to due process, again, elaboration. Notification of the charges, the right to cross-examine and confront witnesses, and the right against self-incrimination, which means they don't have to take the stand. And, of course, the right to counsel, the 6th Amendment right to counsel as well. So, again, this is not just in adult scenarios. This is in juvenile as well. And then the next major case, in Ray Winship, in delinquency matters, the state must prove beyond a reasonable doubt, because it is important that you understand, though we're not criminalizing the individual, we still are operating under some of the same penalties that could take place, with the exception of a few, and we'll talk about what those exceptions are that have gone on. So you'll see the evolution of how juvenile justice has begun to shape and form as I go through this little exercise. And then the following year, McKeever versus Pennsylvania says that jury trials are not constitutionally required in juvenile court hearings. In other words, remember what I told you about how they were closed? The right to a jury trial is a constitutional right in adult court, but not in juvenile court proceedings. Not in juvenile court proceedings. They are not entitled to a jury. And the reason is because of what I said, is that the parents' patriot aspects of it is that the judge sits in the place of the parent in dealing with, of course, the law that's given to them, but at the same time with a goal towards trying to get that person in a position to salvage them or rehabilitate them. So this was a landmark case in 1971 that settled that question once and for all, that all juvenile cases that are tried would not have juries. Then in 75, Breed versus Jones, we get to the point of talking about the waiver to criminal court after adjudication constitutes double jeopardy. So in other words, here's the deal, is that if an individual is tried in juvenile court, they cannot then be waived to adult court because it's two bites of the same apple, operates on the same basis as in the adult court. Double jeopardy, it violates the Constitution, and it gives the state two opportunities to get that child adjudicated and or convicted. So Breed versus Jones, I mean, it seemed that it didn't make sense to be said, but that's the beautiful thing about the law, that you should be aware. Just because you might think it's so or might think it's right, the courts have to oftentimes address the issue because it remains open and settles once and for all. So in 1975, that issue was settled once and for all and made very clear for everyone. 79, Smith versus Daily Mail Publishing talks about the fact that the press may report juvenile court proceedings. Now, notice, if you ever pay attention very carefully to the reporting of juvenile proceedings, they first of all don't report the name of the individual. They'll call it John Doe or Jane Doe, or they won't provide enough information for you to identify the parties that are involved. And so they can report the facts, but they cannot use the names of those individuals and or the witnesses that are involved in those kind of things. So so it said prior to that, okay, if it was sealed and closed, what about the right of the public to be aware of what's going on with juveniles in juvenile court? And so the court struck a balance in 1979 to reach the conclusion that the press has a First Amendment right to report the proceedings, but they must abide by the rules, and once again, to protect the anonymity of the minor involved. Moving right along to 1982 in Edding versus Arizona, a defendant's age, their youthful age, it says, should be considered a mitigating factor to determine whether to apply the death penalty. Now, that is an issue from 1982. We're going to come to a point in a few minutes where that issue has been resolved. What happened is that there was a point in many jurisdictions where the death penalty would not be given to an individual who committed an offense who was under the age of 18 at the time of the offense, not the time of the sentence. For example, I had a young man who committed a very heinous act sometime just before I retired, and I worked out a plea for him, but he turned it down. But the fact of the matter is that by the time the trial came up, he was 18. But it was clear in our jurisdiction that based upon our Supreme Court in our state, that we don't execute juveniles. And so that individual could not be executed. But that individual did end up receiving a natural life sentence and is in jail for the rest of their life when they were found guilty. So this was during a period when they were dealing with aggravating, and mitigating circumstances. Aggravating circumstances were the things that were bad. Mitigating were the things that possibly were good when it concerned the individual. And this is the sentencing aspect of it. This is the sentencing aspect we're talking about here. So in 1982, that was the statement, but that's not the final word. In 84, in Shaw versus Martin, preventive pretrial detention of juveniles were allowed under certain circumstances. In other words, what that meant is that they weren't entitled to be released and were held in custody, just as adults were. And so that issue had to be resolved again. Be aware, if you're paying attention to the flow here, is that there were issues that had to be litigated and challenged by individuals to shape and form the system that we ended up with today. And so this is another example of that situation. So if it was a crime that was serious enough or the individual had a flight risk, then that person was not released and remained in custody pre-trial, even before there was an adjudication. Moving right along to 1988. The minimum age for death penalty was set at 16, and that's in Thompson versus Oklahoma, and that was the lowest age that the death penalty. So if a person was 15 and under, no matter what kind of offense, they could not receive the death penalty. So then we come to 2005. And here's the issue that settled the whole death penalty thing, once and for all, period. The United States Supreme Court stated in 2005 in Roper versus Simmons that the minimum age is 18. And that's where it is today. That's what I was talking about earlier. Notice that there were jurisdictions that were moving in that direction, going back to 16 as the minimum age. The minimum age. Well, now, with this case, the minimum age is set at 18. So that's the earliest that you could sentence somebody to the death penalty. If they're 17 or 17 years and less than 18, you can't do it. It is a violation of the Constitution. So these are some of the important rights and things that took place in the juvenile justice system to shape it to where we are now. Okay, so let's conclude by going over the parents' patriae. I already talked about it, but again, a Latin term describing where the English kings established the right to intervene in the lives of the children of their monarch. And that's the same thing that the judges do at the present time. Okay. Juvenile delinquent. What is a juvenile delinquent? A minor who violates criminal law, whether it's truant or incorrigible. That's what we call a juvenile delinquent. So that person's been adjudicated. Status offender. Juvenile who engages in behavior that is illegal only because of their age. It is illegal only because of their age. That's when we get into the status aspects of it. Community treatment. Effort to provide care, protection, services, and treatment to juveniles in need, such as we talked about earlier, probation, counseling, and restitution. Again, remembering the purpose for the juvenile court system. Residential program speaks for itself, in which placement is done through social services, in group homes, family group homes, wilderness programs, or boot camps. And, you know, I have advocated many times for boot camps. I have seen individuals go into boot camps and come out different individuals because they do not, I mean, it's just like going through the military boot camp, but even worse because of the fact that if you have an opportunity to do some research on boot camps, you will discover that the reason why we're having trouble, why don't we have more boot camps? The B word is involved, budgetary restraints, and it would solve a lot of our issues. Non-residential programs, the opposite. In other words, offenders that do not confine them overnight, very simply that. Aftercare, parole. So that's what happens. It's not called parole. It's called aftercare. Remember, let's see the terminology. It's again, you got to look at the reasons for what it is and the intention of what's involved. What's a judicial waiver? Intake personnel, prosecutors, or judges who make a decision to send the individual to adult court. That's the waiver process that you have a written assignment to deal with, understanding what that is all about. Okay. A social investigation report is before I put it over, it actually is the same thing as the PSI, what we call the pre-sentence investigation in adult court, where the background of that individual is gathered to help the probation officer as well as all the attorneys and the judge to reach a proper disposition for that individual. Statutory exclusion in certain states that automatically transfer juvenile offenders to adult court for certain offenses. And again, it's different statewide, countrywide. Every state has a different. Some don't have automatic transfers. We in Illinois, my last recollection is that we didn't have automatic, but I think they're probably moving toward it if they haven't already done it. And that's the end of that exercise there. So having gone through that, it makes it pretty clear what the purpose of the juvenile justice system is all about, and understanding the purpose and intent. It's like an extension of social work. And again, it's your parents can't control, or the guardians can't control, so the court steps in as the parents and take them through the system so as to utilize the law that they have and the authority under the legislation of the jurisdiction in which that individual commits the offense to help them to try to change their direction in lives. And that's the whole thing in a nutshell. Any questions, comments? Okay, Clifton? John? Okay. Well, let me say again, I want to thank you guys for coming out to the final lecture. I do want to take the time to say to you and to each of your colleagues, classmates, that at the beginning I said I laid out the foundation for what my expectations were. I remained consistent, firm, and fair throughout the whole quarter, and I tried to make sure that you were aware of how to get an A in this class, how to do well in this class. And most of you abided by that. I have this class consists of 2 sections. Of my 88 students, half of the 88 is this class, sections 1 and sections 2. I will be continuing to teach this again. Most of you won't see me again in this class. Some of you will, just a handful will. But the point of the matter, not even a handful will, I'm happy to say. But the point of the matter is that I try to tell students very seriously that, as I said from the very beginning, my goal is to prepare you utilizing the transferable skills that we went over in the open house, that are in your syllabus, and that all professors should be enforcing, to make sure that you are prepared when you receive your degree from this institution, that you are qualified to perform in the field that you choose. If it's corrections, or if it's an adult corrections, juvenile corrections, if it's law enforcement, whatever it is, lawyers, whatever you decide to do, that we have a goal of making sure that you are exposed to information. I've shared my experiences throughout the quarter and made sure that you got the information that you needed. And so anyway, I continue to wish each of you the best. Those of you who perform well, I commend you. Those of you who did not, I say don't stop, don't be deterred, don't turn around, don't quit. When I was in school, one of my albatrosses was math, and I'm talking about calculus and algebra and stuff like that. But you know what? I didn't run away from it. I went and got help. I got a tutor to help me. I took extra classes. I took my lunch hour to study hard while I was in high school. And then when I went into college, I didn't dodge it either, because if I had something that was hard for me, that was standing between me and the goal that I intended on, and that was obtaining my bachelor's degree and then going on to law school and becoming a lawyer, I had to keep the mindset regardless of what happened. Based on what I shared with you at the beginning of this course, adversity is the springboard to success. To use those circumstances and situations to launch me and to continue to have me moving forward. As the late Walter Payton, who I knew, Walter said to me, he says, I could run east-west all day long and dance around. He says, but I'm not helping my team until I can go north, or south. But anyways, ahead of you. The point of the matter is, going east-west, you're staying in the same place. Actually going south might be backtracking, but the key thing is to go north and go in the direction that helps you to gain ground. Well, that's the same thing that you want to do with your opportunities here. You guys spend good money, you get a good education, and you can excel just like anybody else that you'll come into contact with. And that's the goal of myself and many of my colleagues, but I can certainly assure you that is, I don't deter or change from that anyway. Then the final thing I want to say is that if after the class, if you have any need, or you need a reference, or you need some something to help you further in your career, feel free to reach out to me. There are people in my classes who know that they can do that, and I extended every course that I teach. And I have written letters, made phone calls, used some of the contacts that I have in the fields that you guys are going into, as I said before, in corrections. I know people who work in corrections. One of my, I talked about one of my students who's on her way to law school now. She's got her bachelor's, and she graduated with honors with her associates and bachelor's while working in corrections. Went from lieutenant, well, she went in there first as a officer, then worked her way up to lieutenant, and then as far as she can go, the highest next to ward is major. And now she's at the point she says she wants to launch out and become an attorney. So in the criminal justice field, and I'll be guiding her with that. I do those kind of things for my students, and so you guys can feel free to reach out to me. So with that, I'm going to say good night, and again, been a pleasure having you guys in my class, and I oftentimes have had students who were repeaters with me. I'm not talking about taking the same class, but have been in other classes. So I will say this, that next quarter, I will be teaching this class again, sections 1 and 2 in the summer. I will be also teaching Introduction to Criminal Law, and I love that class as well. And then I will also be teaching crime scenes to conviction, critical skills in written and oral communication. That's a hands-on course which I enjoy teaching, and has helped shape some of the modules in that class. And then finally, I will be teaching critical issues in criminal justice. There's some really exciting things that are always going on. There is a very exciting case that I'm following right now, and I can't remember the name of the case off the top of my head, but it is, let's see if I can find it in my files here, because I just downloaded it yesterday. Let's see. Here it is. It is the case of United States versus Carpenter. This is the Fourth Amendment case that involves the issue of communication and social media, GPSs, and tracking. So that's going to come before United States Supreme Court. They've accepted it, and so I'm going to keep my eye on it. It's a Sixth Circuit case, United States versus Carpenter. If you want to take a look at it, I just got the full opinion. I haven't had a chance to sit down and read it, but I will. But I look at those kinds of things. But this is going to be, man, that's going to be that's going to be an earth-shattering case with technology involved here. And so I'm very interested in keeping up with those kinds of things, and probably be discussing that in critical issues of criminal justice. So, okay, good night, John, Clifton, and everybody else. Have a good one. Okay. Thank you. My pleasure too. Likewise. Good night.